The Supreme Court is once again at the center of a national debate, its marble steps and imposing columns now the stage for a question that cuts to the heart of American identity and values. This time, the justices are being asked to weigh in on the constitutionality of state and local bans on so-called assault weapons, firearms that have become symbols in the ongoing struggle between public safety and individual rights. Gun rights advocates are urging the court to decide whether these bans violate the Second Amendment. They argue that recent Supreme Court decisions have clarified the right to own firearms that are commonly used for lawful purposes, and that these bans go too far in restricting that right. On the other side, supporters of the bans say they are essential for protecting communities from mass shootings and gun violence. They believe states should have the power to regulate especially dangerous weapons, and that public safety must come first. The outcome of this case could reshape gun control in America, determining what firearms citizens can legally own and how far states can go in regulating them. These legal challenges specifically target laws in states like Connecticut and Illinois, states that passed strict gun regulations in the wake of devastating mass shootings. The central question: can states ban popular rifles in an effort to protect public safety, or does the Constitution prevent such bans? Until now, the Supreme Court has largely avoided taking up this divisive issue, but a growing stack of legal filings and recent comments from several justices suggest that the court may soon be ready to address it head-on, potentially setting a new national standard. Both sides of the debate are watching closely, knowing that the next move from the court will send a powerful signal about the future of gun rights and gun control nationwide. The stakes could not be higher, and the nation is holding its breath. As petitions are filed, arguments sharpened, and the country's divisions laid bare on the courthouse steps, a nation waits, anxious, hopeful, and uncertain, for the Supreme Court's next move. To understand the legal fight, we need to clarify what's at stake. Assault weapon is a political term, not a technical one, generally referring to semi-automatic rifles like the AR-15 and AK-47, often banned for features such as pistol grips or folding stocks. These laws aim to restrict firearms perceived as especially dangerous, often in response to mass shootings. Supporters argue these bans are common-sense measures to limit firepower and reduce mass casualties, not a blanket ban on all guns. Many laws also restrict large-capacity magazines to further limit potential harm. Opponents say the term assault weapon is misleading, describing firearms that function like many legal rifles. They argue the banned features are mostly cosmetic and don't make the guns more dangerous. This disagreement over the nature of these weapons is at the heart of the legal and cultural battle now before the Supreme Court. Two major cases are leading the charge to the Supreme Court, one from Connecticut, the other from Illinois. In Connecticut, gun rights groups argue the state's ban on rifles like the AR-15 violates the Second and 14th Amendments. In Illinois, a challenge to Cook County's long-standing ban could also overturn the state's newer, broader law. Both cases argue that these rifles are the most popular in America and used for lawful purposes, so banning them is unconstitutional. Recent Supreme Court rulings emphasizing historical tradition and common use have emboldened these challenges. Lower courts have upheld the bans, creating a direct conflict and legal uncertainty. The petitioners are urging the Supreme Court to resolve this split and provide a clear, final answer. The Supreme Court has sent mixed signals on assault weapon bans. Recently, it declined to hear challenges to bans in Maryland and Rhode Island, suggesting reluctance to intervene. But several conservative justices, including Clarence Thomas and Samuel Alito, have dissented, arguing these bans likely violate the Second Amendment. Justice Kavanaugh has signaled the court will likely address the issue soon, pointing to the Illinois case as a possible vehicle. These statements suggest the court is waiting for the right case to settle the issue. The justices are aware of the confusion in lower courts and the national stakes. Gun rights groups have responded by filing new petitions, hoping to present the case the court is ready to take. Chatterbrom Palberbo, for Inal Vride and a Brace and Brine, Storing Prat Stade. Bobrogri Stalby Bracet for a major Supreme Court showdown. Gun rights advocates argue that AR-15s and similar rifles are in common use for lawful purposes, such as sport shooting, hunting, and home defense. They believe that banning these firearms would violate the Second Amendment, which they interpret as protecting the right of individuals to own weapons that are widely owned and used by law-abiding citizens. For many, The AR-15 is not just a symbol of personal freedom, but a practical tool for recreation and self-protection. They cite Supreme Court decisions like Heller and Bruen, which protect weapons widely possessed by the public and require gun laws to align with historical tradition. These rulings, they argue, set a clear legal precedent that the government cannot simply ban firearms that are commonly owned unless there is a strong historical basis for doing so. Supporters of gun rights claim there's no historical precedent for banning an entire class of common firearms. They point out that throughout American history, citizens have had access to the latest firearms technology, and that attempts to restrict such access have often been met with resistance and legal challenges. On the other side, states and gun control supporters argue these are unusually dangerous weapons of war, not ordinary rifles. They emphasize the AR-15's military-style features and its use in high-profile mass shootings, arguing that its lethality sets it apart from traditional hunting rifles. They point to Heller's allowance for banning dangerous and unusual weapons and argue that modern assault weapons fit this category. According to their interpretation, the Constitution does not protect weapons that pose a unique threat to public safety, especially those designed for rapid fire and high-capacity magazines. States say their bans are consistent with a tradition of regulating new, dangerous technologies. They argue that just as past generations regulated weapons like sawed-off shotguns or machine guns, today's lawmakers have the authority to address the risks posed by modern firearms. They argue the government has always had the power to address weapons that pose an outsized threat to public safety. For gun control advocates, restricting access to assault weapons is a necessary step to prevent mass shootings and protect communities from violence. The debate is not just about public safety, but about how history and the Constitution should be interpreted. Both sides present passionate arguments about the meaning of the Second Amendment and the role of government in regulating firearms, reflecting deep divisions in American society. Both sides believe the Supreme Court's next decision will set the standard for years to come, shaping the future of gun rights and regulations in the United States. The outcome will not only impact current laws, but also influence how Americans understand their rights and responsibilities under the Constitution. Leaders on both sides of the gun debate are making their positions clear, and the stakes have never felt higher. As the nation watches, politicians, legal experts, and activists are all weighing in, each determined to shape the future of gun rights in America. Gun rights advocates like Brandon Combs of the Firearms Policy Coalition insist the AR-15 is protected by the Second Amendment and that this right is non-negotiable. They argue that any attempt to ban or restrict these firearms is a direct attack on constitutional freedoms, and they're mobilizing supporters across the country to make their voices heard. Adam Kraut of the Second Amendment Foundation argues that lower courts are defying Supreme Court precedent and that it's time for the justices to enforce the law. He points to recent rulings that, in his view, ignore the clear language of the Constitution and the intent of previous Supreme Court decisions, calling for urgent judicial intervention. Justice Clarence Thomas has called for the court to stop delaying and decide whether the government can ban the AR-15. He's been vocal in his criticism of the court's reluctance to take up these cases, emphasizing the need for clarity and consistency in the law. Justice Kavanaugh has reassured advocates that the court will likely address the issue soon, signaling to states that their laws are under scrutiny. His comments have fueled speculation that a landmark decision could be on the horizon, one that may set a new national standard. These statements show the intensity of the debate and the expectation that a major ruling is coming. Both sides are preparing for a legal showdown, with rallies, press conferences, and public campaigns ramping up as the Supreme Court's involvement seems more likely. Activists and justices alike agree. A Supreme Court confrontation is inevitable. The courthouse steps have become a battleground for passionate arguments, and the nation's highest court is now at the center of a historic moment. The nation is bracing for a decision that could redefine gun rights in America, with millions awaiting the outcome that will shape the country's laws and values for generations to come. The legal landscape changed dramatically with the Supreme Court's 2022 Bruen decision. Bruen replaced the old balancing test with a new standard: gun laws must be consistent with the nation's historical tradition of firearm regulation. Now, the government must show that a modern law has a historical analog from the time the Second or 14th Amendment was adopted. Gun rights groups argue that assault weapon bans have no such precedent and must fail under Bruin. States counter that the tradition is about regulating dangerous and unusual weapons, not specific features. They argue that regulating new, especially dangerous technologies has always been part of American law. The Bruin decision has shifted the battleground to history itself. The Supreme Court must now decide which historical argument prevails. Since Bruin, lower federal courts have split on how to apply its history-focused test to assault weapon bans. Some courts have struck down bans, arguing there's no historical precedent for them. Others have upheld the laws, calling AR-style rifles unusually dangerous and outside Second Amendment protection. This has created a patchwork of rulings. Whether you can buy an AR-15 depends on where you live. The resulting confusion is exactly the kind of circuit split the Supreme Court is meant to resolve. Gun rights groups say lower courts are resisting Bruin's mandate, while states argue they're protecting public safety. The Supreme Court is being asked to settle this nationwide conflict once and for all. The stakes for clarity and consistency have never been higher. A Supreme Court decision on assault weapon bans will have sweeping consequences. Striking down the bans would invalidate similar laws in other states and affirm the right to own common semi-automatic rifles. Upholding the bans would give states broad power to regulate firearms they deem unusually dangerous, even if they're popular. The court's decision will set the legal boundaries for gun rights and public safety for a generation. The next step is for the justices to decide whether to take up the Connecticut or Illinois cases. If they do, the nation will watch as the court hears arguments and issues a ruling that could reshape American law. This debate is about the meaning of liberty, safety, and the limits of government power. The country waits for the Supreme Court to draw a line that will define American life for years to come.